Yes, good morning.
Morning, my lord. I'm here.
You can both take it that we've read the papers, we've scrutinised the terms, both sets of terms and conditions, or all the various competing sets of terms and conditions. We've obviously read the skeleton arguments. You can assume that we have a lively appreciation of the issues that arise both in relation to the terms and conditions and in relation to the negligent non-disclosure. So we'll leave it to you to take your own course. We'd be pretty confident that you wouldn't necessarily take all day, but you do have all day.
I'm grateful for that, my lord. In that case, I'll dispense with the usual introductions. I appear for the appellants. Larry Frem's a Goodkin appears for the respondents. I won't take you through the factual background. I'll just jump into ground one. Suits. My lords, on ground one, of course, the Rightmove terms, I'm going to take my submissions in three parts. Firstly, setting out the terms that I rely on and what I say their effect is. Secondly, dealing with the reasons given by the deputy judge for finding that there's no prohibition in the Rightmove terms. And then thirdly, picking up some of the points raised by the respondents in their skeleton and their respondent's notice. Now, with the Rightmove terms, you'll have seen there's two versions that have been disclosed to us by the claimants or the respondents. Yeah. The first version is what we're calling the 2019 terms, the 2009 terms. The reason for that is that's when they were first received by the respondents and when they first started the process of applying for Rightmove membership. So when they first became a member, those are the terms that applied. The second version is one calling the 2014 terms, and those are the terms which were in force at the date of the SPA in this case. Now, in my submission, it's 2014 terms that are the most relevant because they were the terms that applied when warranties were given and we entered into this contract. That's really going to be the focus of my submissions today.
Are they not the only terms that we have to consider? Because I noticed that the order that the judge made was a declaration only in relation to the position as to what was prohibited at the time the parties entered into the contract on the 20th of February 2017.
Yeah, yes.
So that
yes.
The appeal can only be concerned with the construction of the 2014 terms, can't it?
Yes, precisely those. They're obviously the judge considered the 2019 terms, which is why you have them in the bundle. I have one point to make on them, but apart from that, I'm going to focus on the 2014 terms. There's one point of construction where I say they assist the construction of the 2014 terms. Apart from that.
Yeah, just as a point of terminology, I'm right, am I not, in thinking that the terms you refer to as the 2014 terms, the judge referred to as the 2017 terms, and one can understand why he used that terminology, because the technical guidelines that you rely upon are dated October 2016.
Yes, well, I was going to pick up, there is a confusion in terminology. The reason I say 2014 is that's the general membership terms that are dated 2014, yeah. But it's the same set of terms. As you picked up, in 2014, the terms are split out into different documents, the general membership terms and conditions, and what we've called the technical guidelines. And those are the relevant bits. They're, of course, linked by clause 4.2.3 of the general membership terms, yeah. Which is where the company gave a warranty that it would comply with any restriction or obligation imposed on it by the technical guidelines. So a starting point is there are restrictions and obligations in the technical guidelines. Now, my lords, as you've seen, we say these guidelines did place some important restrictions on what the company could do. And the principal clause we rely on, in fact the only clause on this appeal, is clause 22 of the technical guidelines, by which the company warranted that it would not, without the written permission of Rightmove, directly or indirectly, in the opinion of Rightmove, sell on or provide access to the services and features of its membership to any third parties. Now, my lords, four points, if I may, by way of introduction about that clause. The first is it's very clearly a prohibition or a restriction on what a member of Rightmove can do. Secondly, it prohibits two different kinds of activity. It prohibits selling on and providing access to the services and features of membership. Thirdly, the scope of that prohibition is extremely wide in my submission. It prohibits engaging in such conduct not only directly, but also indirectly. And the question of whether that conduct is indirect is determined by Rightmove. It has the say on it. So it's extraordinarily wide prohibition. The fourth point is the point on the 2009 terms, which is that this prohibition was expanded between the two versions. And Mullers might have picked that up already, but I can show you. Just look at the 2009 terms. So that's tab 5 of your supplemental bundle, page 62, which may be difficult to read in the A5 copy. It's the very small print.
Page
62. So at the top right-hand corner, maybe I have it in A4 if my lord would prefer a larger version. But it's
you have a young and vigorous constitution this morning, and we can manage to read the writing. Anything smaller I would have struggled with, but I can manage this.
I'm grateful, my lord. You can see that, well, firstly, the equivalent version of this clause that we rely on, it appears in the general terms and conditions in 2009. And of course, my learned friend takes a point that this, in the 2014 terms, appears in the technical guidelines. Well, previously it appeared in the general terms, now it appears in the technical guidelines. In my submission, there's nothing in the location of the clause. The question is what it says. And in 2009, clause 19, you'll see the difference is there's no reference to direct or indirectly providing access or to the services and features of Rightmove's membership. So those words, directly or indirectly, are added in the second version of the terms. And so the prohibition is expanded. In my submission,
sorry, I must be in the wrong place because I'm struggling to find. I thought you said D19?
Sorry, no, C19.
C19.
Just above D at the top right of the page.
Right, thank you.
Yes, you warrant that you will not, without a written permission, sell on the services and features of your membership or provide access to those services and features. You can see how the prohibition has been expanded. Now, my submission, the obvious reason for that is to remove any doubt about what selling on or providing access to the services and features of membership are. Because if there's any doubt, Rightmove now says, well, you can do it directly or indirectly, and we prohibit it in either case. So that deals with the sort of technical arguments about how you characterise the services that are being provided, which we'll come to.
And this clause, C19, in what you describe as the 2009 terms and conditions, this is referred to in the judgment by reference to your submissions and your argument. It isn't entirely clear whether that's expressly addressed in the discussion part of the judgment.
I agree with that, my lord. A point's taken by my learned friend, which I was going to come to, that we've changed our case, or that we didn't rely on clause 22, the 2014 terms below. I don't accept that. I accept that below I relied on some additional parts of the terms, which I don't pursue. But I quite clearly relied on this clause in both the 2009 terms, when it was at C19, and also in the 2014 terms, when it was at 22. And you can see that, I don't need to go to it, you can see that from my skeleton argument below.
And you can see it in the judgment, it's more important. He refers to that and your submission about that at paragraph 42 of the judgment.
Exactly. So this is a point that was considered below my submission. So that's the clause that we rely on and how it's evolved between the two sets of terms. Now, in my submission, that clause is either intended, or certainly apt, to prohibit precisely the kind of conduct that the company, in this case, was engaging in on the facts. The services and features of being a member of Rightmove include most obviously the ability to place adverts for properties for sale or to rent on the Rightmove website and platform. That's the most obvious benefit of being a member. And in permitting agents to use the company, as the judge put it, as a sleeve through which to place adverts on behalf of their own clients, in my submission, the company is either selling on or alternatively providing access to the services and features of Rightmove membership. And to the extent there's any doubt about that, it's either doing it directly or it's doing it indirectly. The company could hand out its username and password to third parties, or it could post adverts for them. Either way, that conduct's prohibited in my submission. And the claimants say in their skeleton that we adopt a strange and erroneous interpretation and engage in a complex process of legal analysis. Well, my lords, in my submission, it's quite the opposite. In my submission, it's simple and obvious what Clause 22 says and what it prohibits. So that's Clause 22. And what is more,
accepts that any third party means anybody other than the two contracting parties?
yes, my lord, I'm going to come to the third party's point because I could deal with the judge's reasoning first if I may, but I will come to the third party's point just raised by my learned friend. What I was going to say is, in addition to the terms themselves, we also have the happy coincidence that our interpretation accords completely with what Rightmove say their terms mean and how they've applied them in practice for a number of years. My lords, you've probably seen Rightmove sent a letter to the court the day before the hearing which set that out. I wasn't going to turn it up, but you have it at the first tab of your supplemental bundle where they explain that our interpretation accords with how they've always understood their terms to apply. And as far
Why
as
is that letter admissible?
well, my lord, there was obviously an issue raised by Lord Justice Stuart Smith about whether Rightmove would intervene. They haven't intervened, but what they have done is sent a letter. And it's right, I should draw your attention to what they say their position is on their terms. I don't suggest that that's the term.
Why is it admissible? Because it's a statement of their subjective understanding. Why is that admissible?
Well, I don't rely on it as evidence of how you should reach your decision, what the terms mean. All I say about it is that it shows what Rightmove's position is. It's important because it shows the practical consequences of this construction. Because if Rightmove's taken a different approach in practice for a number of years and have suspended people left, right and centre for breaching this prohibition, and they've done that wrongly, then there are wider consequences of the judge's decision.
But as you've just pointed out, they had the chance to intervene and they didn't.
They didn't, my lord. But whatever Rightmove's position is, I put my case on the basis of the terms.
Yeah.
Which we first.
And Rightmove, in fact, say that the prohibition is also contained in clause 11.8 of the general terms and conditions, but you don't support that.
I prefer the more specific term. There's a general prohibition on assignments of benefits, but then they go on to deal with clause 22, which is the more specific prohibition, which actually deals with the issue. So I don't necessarily disagree with their position on that. I don't rely on that as part of my case.
Well, I think it may not matter at all, but the letter makes perfectly clear that they regard the prohibition coming within the words in 11.8 of transferring any benefit interest under the contract.
Yes, my lord.
That's what they say.
That is what they say. Other than
then they say it's supplemented
yes.
by clause 20.
Yes,
clause 22.
it may be that it's prohibited by both, but I prefer to put my case on the basis of the clause in the technical guidelines. It's in my submission a clearer prohibition.
Thank you.
Well, lords, that's the clause itself and the terms.
And you'll come on at a time convenient to you to deal with the third party.
I will, my lord.
Yeah.
Yes, absolutely. What I was going to say at this point was that in my submission, whatever the subjective position of Rightmove as to what their terms mean, looking at the matter objectively, our construction makes the most commercial sense of these terms. Because if there is, on the claimant's case, if there's no prohibition to be found anywhere on agents or members advertising on behalf of other agents, then it's obvious in my submission that there's been no incentive for other agents to become members of Rightmove. And there'd be no incentive for them to pay Rightmove's very substantial fees, which just, to put some colour on that, Mr. Pike gave some evidence in his statement, the hearing below, that the annual fees are approximately £20,000 to £22,000 to be a member of Rightmove and Zoopla for a year. So these are expensive memberships.
Well, that all depends on the price they have to pay to the member, doesn't it?
Yeah, the price to the company, my lord, you mean?
Yes.
Yes, which is much lower. He goes on to explain that. So the price to use MyLet to place an advert, the highest you would pay is £69.
Well, that's because that's what they have chosen to charge. It doesn't necessarily mean it's going to be cheaper for a professional letting agent to do it through somebody else rather than become a member themselves. That all depends how cheaply they can find somebody who would be prepared to do that.
It does, but the particular problem with the agents that we're re-sleeving in this case are small agents. So if you only have a small number of adverts each month, then to pay £29 or £69 per advert instead of the very large memberships from Rightmove makes more sense, and that's why this problem arose on the facts, and why you see people engaging in this conduct. But my submission on the commercial common sense is...
Well, if we're looking at the commercial
yes.
objectives, why is it not in the interests of Rightmove to enable people to put their properties on the website in those circumstances? A, it may mean that the member has to pay more, may or may not, but B, it increases the volume of property on the website itself, which of course is a commercial advantage for any website of this nature. More properties they can be seen to have, the greater the share of the market they can be seen to have, the greater the momentum and pulling power.
Well, it might be the case that you end up with more properties being advertised, but my submission of the problem that Rightmove identify, is that they lose membership revenue, and that's how they make most of their money. That if you have a high street, let's say Upper Street, with 10 agents, 10 traditional agents on it, the normal case in my submission is all of those agents, be they Foxtons or whatever, they each apply for an individual membership and say that costs £20,000, it's £200,000 worth of revenue.
But you're presupposing that the only source of revenue for Rightmove is membership fees. Now, I don't happen to know whether that's correct or not, but one could easily suppose that it's not correct, e.g. because they carry advertising on the website and make money from the advertising, in which case it could be the case, I don't know, that the quantum of membership fees is actually pretty irrelevant from Rightmove's point of view, and the key consideration for them is to maximise traffic to their website and maximise their advertising revenue. After all, that's how companies like Google work, we know.
Well, there's no evidence produced by either party as to how additional revenue is generated from Rightmove. The only evidence we have is that they make money from membership.
Yeah, but you're putting forward an argument based on commerciality, which all depends upon an economic analysis, which depends upon how these things actually operate in practice, as to which there's no evidence, and it's a matter of speculation. So how can we go there?
Well, my Lord, maybe you shouldn't have gone down the path of adopting additional arguments about commercial common sense, because my submission is the meaning of the terms is clear on the terms.
Sure.
Then trying to explain why the prohibition exists, well, my submission, a reason would be because you would lose membership revenue. An additional reason is you'd lose control of your membership. And obviously the advantage to anyone that runs a club is that you get to decide who comes in and who doesn't. Now, on the claimants case, instead of deciding which agents come in, you would lose control over that, because additional agents who you don't have any oversight over could be getting onto the platform. So it's not just revenue. There are two reasons why you would prefer this prohibition if you're a Rightmove's position. Just before we finish that off, the point made by my learned friend is, well, it doesn't matter because there's a clause in the terms that says you can just increase the prices. There are two answers to that, my lords. Firstly, that clause 5.4, only kicks in if there's a breach of the terms. So it's all premised on there being a breach of the terms and the conditions, or breach of the technical guidelines. So it doesn't assist you in trying to work out if there's a prohibition. You have to have a prohibition that's breached before you get to the right to increase the price. I can show you that at clause 5.4, which you have at tab 20 of your core bundle. So page 230, at the bottom at 5.4, as I understand it, that's the clause that my learned friend relies on. It says if your data does not comply with the requirements in the technical guidelines, or in Rightmove's opinion, does not originate from one of your locations, then you will pay Rightmove's additional charges at the prevailing rate for providing these additional services. So it's all premised on there being a breach of the terms. It's then said that this is the exclusive remedy of Rightmove if there's a breach. And that's also wrong. I should just show you that. If you go over the page, 2 pages in fact, it's 232. At clause 10.2.1, Rightmove, of course, has the right to terminate your membership for a breach of the terms. 10.2.1. And then over the page again, 10.3, without prejudice to any other rights in these conditions. If Rightmove has any reason to suspect that you're not willing or able to comply with the terms, it can immediately suspend your membership. And of course, that's what happened on the facts. So there's a whole suite of rights that Rightmove has, and you can understand the point. There's a prohibition on this type of conduct, we say, and if you breach it, well, Rightmove wants to be able to take action, and it wants to be able to recoup, I say, lost revenue by charging you more. It could also suspend you, as it did in this case, or it could terminate your membership. So that's the clause about pricing that my learned friend relies on. But in my submission, it also doesn't assist for this reason, which is if he's right, you would get into a situation where Rightmove could potentially have one member, let's say in the Outer Hebrides somewhere, just one member in the entire country that pays membership fees. And all of the other agents in the country funnel their business through the membership of that one agent, rather than having the scenario I posed to you earlier, which is a high street with 10 agents, all of whom sign up, all of whom pay membership fees regularly in the way you might expect. Now, in my submission, that's not a sensible position for Rightmove to get itself into. There are obvious problems with that. There are administrative problems with monitoring what's going on. You would have to charge your one member, you'd have to increase the fees charged that one member, potentially exponentially, to make up for the lost revenue from all the other agents who are funneling their business through the membership of this one agent.
Well, that would soon put a stop to it, wouldn't it? I mean, all you're really submitting is that it depends on how Rightmove decide to undertake their charging. And all we know about that in this case is what we can divine, or at least all I know at the moment, I haven't read the underlying witness statements, is what one can divine from the membership application form, which looks as though it's branch-based. You pay so much per branch. And when we look at clauses that deal with different branches, we can see that there clearly is an intention that you shouldn't, if you're Foxtons, only pay for one branch and then put all Foxtons' business through that one branch. And that's because of that particular charging structure. But the example you give means that they'd soon put a stop to that by not charging per the one Shetland branch, wouldn't they?
Well, they would have to charge that branch more.
Yes.
Yes, but my point is simply it's not possible. If you would have to charge that branch a extortion.
Yes, and that branch wouldn't therefore do it, and therefore Foxtons wouldn't be able to put all their business through a Shetland, another agent. And if Foxtons wanted to use Rightmove, they'd sign up themselves, no problem.
Well, the example I give is just to illustrate the potential consequence of the claimant's construction. It's perfectly possible you get into that scenario with one member in the country, in my submission, which would not make sense. So that's the arguments about the charging structure and the consequences of these clauses. But as I say, it's perfectly clear what the prohibition is in clause 22 in any event. Well, we've dealt with the terms. I should pick up the judge's reasoning in the judgment. In my submission, there's two main reasons the judge gave.
I'm sorry to interrupt you again. I'm doing a lot of interrupting, but just before we do that, can I just ask you a couple of points about the structure of these terms?
Yes.
And there are 2 points really, and they point in different directions. One is this: we've got in the terms and conditions themselves a conflict resolution clause which says essentially that the terms and conditions take precedence over the technical guidelines in case of conflict. And we've also got in clause 11 different provisions as to the ability to amend.
Yes.
In the case of amending the terms and conditions themselves, you have to have a notice period, you can have objections, you have negotiation, and you have a right to cancel if the member doesn't like it. Whereas as I read 11.2.2, there's simply an absolute entitlement to change the technical guidelines by giving notice. And both of those would suggest, as does the title and as does the content of at least most of the technical guidelines themselves, that they are not really concerned with such a fundamental point as to what properties you're allowed to advertise, which is the market, which is the service, but more technical aspects. So that's one point. And I then, I'll put the other point because maybe you'll say this is the answer. We do, however, in clause 11 of the technical guidelines, have a provision which you haven't referred to or identified, which is headed marketing your properties and is a warranty in relation to the data that can be uploaded, which it may be said defines what properties are appropriate to your membership and can be uploaded. And the first bullet point is where you or your client received the original instruction from a third party.
Yes.
Now, you don't rely on that as being the prohibition, but the point I wanted to put to you is, given that that does seem to be dealing with essentially what properties you're allowed to market on the site, might it be said that that's where you find any relevant restriction, and that clause 22, talking about selling on or providing access, has to be read in that light, and the activity that clause 22 is aimed at is not which properties you're allowed to put on the site, but that sell on or provide access to it is rather more limited.
Well, Lord, you have been kicking myself, because clause 11 of the technical guidelines, of course, one of the clauses I've relied on before,
yes,
below for the judge.
But you're not relying on it on this
No,
appeal.
my Lord, I don't want to take a position that's inconsistent with Rightmove. Of course, Rightmove in their letter don't rely on clause 11; they rely on clause 22, which they say is the prohibition. So I don't pursue. I haven't pursued clause 11 as part of this appeal. But what that does show you, well, do your first point about the technical guidelines. There are a number of answers to that. The first is the point I've made to you already, which is when we look at the previous version of the terms, this same clause, or the equivalent version, was in the main terms, and now it's in the technical guidelines. So previously, when you see that, my submission, there's no special magic to where it now appears. It just happens that it's now in the technical guidelines.
Well, you say that, but as my lord has pointed out to you, there's a clear difference between the two sets of terms in that it's not simply a case of the terms being spread across two documents, but also the later terms expressly create a hierarchy. They say in terms that the terms and conditions prevail over any inconsistency in the technical guidelines. Now, that's something we can't simply blithely ignore, can we?
No, my Lord, I agree there's the inconsistency resolution provision. My submission is always a last resort to simply ignore terms in the technical guidelines if they're inconsistent with the general terms. And in my submission, you can read them consistently, and that's the preferable outcome. It's only as a matter of last resort that one then says, I don't know what this technical clause 22 is doing. It seems inconsistent with some other parts of the general terms, and therefore we'll park it. We'll just not attribute it any meaning. That's a position of last resort, and not one that we need to come to.
Did the 2009 terms have the same equivalent provisions, both as to amendment and as to prioritising by way of hierarchy? Do you know?
Well, no, I would need to check the amendment point. I don't think they have an inconsistency clause. I would need to check. It's not a point that's arisen before.
All right.
You can
come back to us.
We can come back to that. Might be easier way of dealing with it. But that's the point of the technical guidelines, my lord. And in any event, as I showed you at the start, the general terms clearly anticipate that there are restrictions and obligations imposed in the technical guidelines, a warranty given that you comply with them. The final point is that if I'm not right, then clause 22 must be dealing with some completely different kind of scenario, and in my submission, it's difficult to see what that alternative evil clause 22 is directed at. So that's again the terms. Briefly, I was going to deal with the judge's reasoning. In my submission, there are two main reasons given in the judgment for finding that there was no prohibition in these clauses. The first is that there was an insufficiently clear statement of it, the judge says, and the point could have been beyond peradventure by plain drafting. And the second point is because of the definition of your client and the fact that that potentially included an agent as well as developers, landlords, and other property owners. Now, the first point, well, we can do it very shortly. In my submission, it's simply a truism. It's always the case that the parties could have spelt out the clause in clearer terms or used different words. But that's rarely a helpful line of inquiry, as the authorities make clear. They're summarised, I'm not going to take you to them, but they're summarised in the extract from Lewison, which you have at tab 5 for your authorities bundle. The relevant question in my submission is, what did the parties mean by the words that they actually used? And in this case, that included clause 22. Now, it's true that they could have used different words. They could have singled out a specific type of conduct, so allowing other commercial letting agents to use your membership. But they didn't do that. They drafted a more general prohibition, and it may be that prohibition is sufficiently wide that it catches other types of conduct as well. But for the reasons that I've given, it's perfectly clear in my submission that it's sufficiently drafted to catch the type of conduct that arose on the facts, and therefore clause 22 applied. The second point dealt with by the judge is the definition of the client. And on that, my lords, my submission is simply a red herring at that point. And I accept that there is a definition of your client, which potentially includes an agent in the general terms. My learned friend seeks to elevate that to some kind of express permission to advertise properties on behalf of other agents. I think that's, in my submission, that's wrong. It's simply a definitions clause. It defines the words your client for the purposes of other terms in the Rightmove terms and conditions. It doesn't confer any substantive permissions or rights. And in any event, one doesn't just simply stop at clause 1, the definitions clause. One has to construe the contract as a whole, which includes a lot of other specific terms, including the prohibition on reselling in clause 22. Now, in my interpretation, the definition of your client doesn't actually cause any problems, because as I showed you, the prohibition in 22 is on members selling on or providing access, directly or indirectly, to the services and features of their membership without the written permission of Rightmove. So in my construction, it is possible for a member to advertise on behalf of other agents. You simply would have to obtain the written permission of Rightmove to do so. So there's a default prohibition in clause 22, but if you obtain permission, you can. And that's why your client, the definition of your client potentially includes an agent, because potentially, if you comply with the terms, your clients could include an agent. In fact, in my submission, that explains why your client's defined so broadly, because Rightmove needs to ensure that its terms can cover all potential situations which might arise, however unlikely. And so the words your client were used elsewhere in the terms. They need to ensure that they potentially could still apply in that scenario. The problem the respondents have is that it's common ground, as I understand it, that they never sought or let alone obtained any permission to advertise on behalf of other agents. So in my construction, that written permission is never obtained to advertise for other commercial agents, and therefore the general prohibition in 22 remains in effect and continues to apply. That's how I deal with the your client definition. On the judge's interpretation, in my submission, there are only two possibilities. Either you say that your client definition is inconsistent with clause 22, and you have to disregard one or the other. And for the reasons that I gave, that's not an attractive position. Clause 22 is obviously, it's a standalone clause. It has been carefully drafted. It's clearly meant to have some effect. And in my submission, the court should give it that effect, shouldn't simply disregard the clause.
I'm struggling a little still with your position on the conflict resolution clause. I mean, as it happens, both parties in this court say that clause 22 can be construed consistently with the general terms and conditions. You just adopt opposing ways of reaching that result. But if the court came to the conclusion that it wasn't possible to construe clause 22 consistently with the general terms and conditions, then the contract itself says in terms what the answer is, namely that the general terms and conditions prevail. Now, why is that not A, perfectly orthodox and perfectly reasonable as a solution to the problem if the problem exists?
My lord, I accept it's a potential answer under the conflict resolution clause, but my submission is one just doesn't get there because there is no inconsistency.
Well, sure. But that's your point, isn't
Yes.
it? Is
Yes.
you say the clause means what it means, and that's not an inconsistency.
Exactly. So one just simply doesn't get to that mechanism in the
Yeah.
contract. The alternative way of dealing with it would be to say, well, Clause 22 must have been dealing with some other different kind of conduct. It's a prohibition of something else. And of course, the judge doesn't spell out what the alternative meaning of Clause 22 was. Doesn't say what other kind of conduct it was meant to be addressing, if not the conduct that I say it was meant to be addressing. So that is a problem with the reasoning in my submission. So either you've got to say it's inconsistent, or you've got to reconcile it.
In your skeleton, you refer on a couple of occasions to paragraph 51 of the judgment.
Yes.
I'm about to say, speaking for myself, I couldn't see that this was purporting to deal with clause 22 at all.
My lord,
I mean, he refers to this thing about the sentence above the signature block, and I scrabbled through the earlier part of the judgment to try and work out what he was talking about. But whatever it is he's talking about, he's not talking about clause 22 there.
Yes.
That's because he deals with this clause earlier, doesn't it?
Yeah.
He mentions your argument in his discussion section, or refers back to it at the end of 48. It's the last sentence, the proscription in relation to selling on the services to third parties bite. So that's where he's referring back to your argument.
Which was
and then
by
in
reference
49,
to clause 19.
Yeah, 49 he says, this in my judgment cannot be right. And then he says that can't have been intended to have opened the door so wide by virtue of the definition of the client, agent's mechanic, only then to have sought it closed again by means of a careful scrutiny of several positions, etc., etc. So that's where he deals with it to the extent that he does.
Yes. Yes, that might be what I was trying to do is suggest trying to explain the judge's reasoning. It seems to me there's two ways of reading it. You can either say these clauses are inconsistent, or you have to explain what clause 22 means. And if the judge didn't say that they were inconsistent, then he doesn't explain what the alternative interpretation of clause 22 is. So it's one or the
But
other.
either way, you accept it's nothing to do with 51.
Well, I think it wasn't clear. The other point is the judge does refer to Chitty on contracts on the resolution of inconsistency, which wasn't cited by me. I don't believe it was cited by my learned friend. So there are 2 points in the judgment where the judge talks about resolution of inconsistency. It may be that's not the approach he took. It may be he didn't decide that.
So if taking my Lord's point, that this is essentially addressed at paragraphs 48 and 49, the opening of the door and the closing it again, is there anything else you want to say about that? I mean, I appreciate you say that the definition of client is a red herring, and you've made that submission, explained why. Is there anything else about what the judge says at 48, 49 on this point?
Well, no. The client issue is a short issue in my submission, and can be dealt with for the reasons that I give. Those are, in my submission, the two main reasons given by the judge, and they don't work for the reasons that I've given. I should then deal with the additional arguments raised by the respondent. As I've said, the judge didn't explain why clause 22 doesn't apply on the facts, and the respondents have attempted to plug that gap by coming up with additional arguments. One of which is an argument about how you characterise the services provided by Rightmove, and they say you should characterise them narrowly. There's a distinction drawn between the ability to place adverts on Rightmove and the act of placing an advert or having an advert placed. It's a very fine and technical distinction in my submission. The argument then goes on that the only service provided by Rightmove is the ability to place adverts on its website. That's the service it provides to its members. And so the respondents say, well, when the company accepts business from other agents, it's simply placing adverts It's not giving those agents the ability to place adverts, and it's not therefore selling on or providing access to the services of Rightmove's membership. That, as I understand it, is the argument. In my submission, that's dealt with by points I've already covered, that if that's not direct selling on or providing access, it's certainly indirect selling on or providing access. The company can either let other agents onto its membership by handing out its username and password details, or it can place adverts for them. That seems to me to certainly be indirect selling on or providing access. In addition to that, as we've seen, it is Rightmove that determines, in its opinion, whether there's been indirect reselling, and as we've seen, Rightmove believes there has been indirect reselling. I've also shown, my lords, the difference between the 2009 and the 2014 terms, the introduction of the words indirect selling on and providing access. And as I've said, the reason for that, or an obvious reason for that, is it's covering arguments like the kind of arguments the respondents try and make, artificial distinctions between the type of service being provided or the type of conduct and what it's doing. And the clause, they expand the prohibition just to cut through arguments like that. You're either doing it directly or you're doing it indirectly. So that's the respondent's first point about the services provided by Rightmove. The second point is the third parties point, which my lord raised. And they say, well, on my submission, on my construction, there's a problem. Because if third parties means any and all third parties, then clause 22 prohibits even members allowing private landlords to use their service and advertising properties for them. Well, it's common ground that the company was allowed to do at least that all normal estate agents on the high street use Rightmove to advertise properties on behalf of private landlords, the owners of residential and commercial properties. So in my submission, the starting point is it's unlikely that Rightmove intended to prohibit that conduct, and therefore third parties in clause 22 must mean some other class of persons. Now the claimants mischaracterise our case on that in their skeleton. They say we're saying that the words third parties mean commercial letting agents specifically. That's not our case. Our case is that third parties simply mean any other party that would be eligible to be a member of Rightmove. And that makes sense, my submission, because what you're prohibited from doing is selling on or providing access to the services and features of Rightmove membership to other parties who could have been and should have been applying for that membership in their own right. Now that includes other commercial letting agents and estate agents. It may include other parties as well.
Why would a private landlord not be eligible if it wanted to become a member? Why would it not be able to do so?
My understanding is that they are not eligible to be members of Rightmove. There are some documents on that, which I can show you. But
how do you get that out of the terms and conditions? Because it's the terms and conditions we have to construe.
Yes, my lord, I can show you the...
Okay, sorry. We need to take this argument in stages. So the first question is, just looking at clause 22,
yes.
What wording in clause 22 you rely upon as limiting the meaning of third parties? Then we can go on to the question of whether private landlords are eligible under the terms and conditions or not.
Well, I don't rely on wording within 22 itself. 22 just refers to third parties. My submission, one has to read that in the context. I mean, not all third parties, just other parties who could be members of Rightmove, which includes other commercial agents.
We'll take it in stages. Third parties is an expression which defines something by reference to what it's not.
Yes.
And prima facie, one would think that it might mean not a member, or it might mean not a member or a client of a member. Neither of those will do for you, for the reasons the respondents say. One proves too much, because it catches residential landlords, and the other fails to catch clients who can, because of the definition, be letting agents. You say that there's a third meaning, that it means those who are not members and are not eligible to be members.
Yes, well that's right.
So it's an extended definition. Third parties doesn't just mean not members, it means those who are not eligible to be members.
Well, in my submission, they'd be the same thing, because not members are people who could be members but are not, which is potentially other agents or other estate agents, but not private landlords who are not eligible. So you or I, my lord, cannot, certainly as I understand it, become a member of Rightmove to advertise a property which we might own in our own right. The membership class is limited to estate agents, professional agents. I can show you that in the documents, my lord. That would assist. But
When you say in the documents, as I understand it, there's something else you want to refer to other than the terms and conditions. Is that correct?
yes, my lord. First, I'll show you in two places.
Well, I mean, we certainly need to look at whatever you're relying on. I'm not trying to stop you, let me be clear. I just want to structure it so I can understand how this fits in.
Yes.
Is there anything in the terms and conditions themselves that you rely upon as limiting the scope of potential membership?
Well, my lord, in the case of Rightmove, the document I was going to take you to is the application form, which forms part of the terms and conditions. So the contract with Rightmove is the application form plus the general membership terms and conditions, plus the technical guidelines. So I was getting that's at tab 19 of your bundle.
Yeah.
Which is this is as filled in by the respondents when they joined Rightmove. Hopefully you see in the first box, so you go to the bottom of the first box and then one up. You have to state the nature of your business: UK residential sales only, UK residential lettings, UK residential sales and lettings. And you have to tick one of those boxes. And obviously, if you're a private landlord, my submission, you can't, because you just are a property owner. The only parties who can tick those boxes.
Sorry, if I'm a private landlord letting my property, why is that not aptly described as residential lettings?
We're taking a combination of it. It's the nature of your business. So it suggests it's your business is residential lettings or residential sales and lettings.
Yeah. Well,
Why is that not business?
If it's a buy-to-let, for example, a very common scenario these days, why is that not a business?
Yes, well, I take your point on the membership conditions. It's also the position of Rightmove set out in their letter that the only people who could be members of their platform are estate agents and letting agents. They make that clear in their letter. It's clearer in the Zoopla terms.
Let's not mix them up, please.
We mix up a bit, but it might be very odd if they took a different position, given their equivalent businesses in the same, operating in the same space. The Zoopla terms make it clear that a member is either an agent or a developer. They don't include individual landlords.
Well, you've taken us to this membership form as the first piece of evidence that membership is limited to professional agents.
Yes.
What's the other evidence you're referring to?
Well, there's two other pieces of evidence. One is the Rightmove letter, which I've taken you to already. I've got tab 1 of your supplemental bundle. In the main paragraph, Rightmove's business model permits estate agents, letting agents, new home developers, and commercial agents, referring to general terms and conditions as members, to advertise properties on the Rightmove platform on behalf of their clients. So they make it quite clear who they permit to be.
Well, that's a description of their business model. They don't actually identify any contractual term which limits membership to those classes of persons, do they?
They don't. Well, obviously, they are the arbiters of who becomes members of their platforms. We're making it clear that if a private landlord was to apply to join, that is not someone they allow to be a member of Rightmove.
Would a company, let's say it's called Grosvenor Estates Management Agency Limited, that is the company that handles the letting for all the Duke of Westminster's large properties as a landlord, would that one company be allowed to become a member? Is there anything that stops that?
Well, it does seem to suggest that large developers or large professional...
You wouldn't call the Grosvenor Estate a developer. You would simply say it's a commercial agent. That one company is a commercial agent for landlords.
Yes, well, it might fall within the term commercial agent, the left ITV2. In my submission, though, it doesn't actually matter. We've slightly segued on the third parties point. You've got my primary position on what third parties mean in this clause, which is consistent with the position Rightmove take in that letter. At the bottom of the letter, they go on to explain what they understand third parties to mean in their terms and conditions.
Well, we're pursuing it because you say third parties means a party who would be eligible to be a member, and we're therefore trying to define
Yes.
quite carefully why it is that you say that private landlords would not be, which seems slightly surprising if a private landlord who has 100 properties and says, I let all my properties through management company. And if the management company can be a member,
Well, I was saying, from the letter, that's my understanding of how they operate the business and who they allow to be members. But the point I was going to make is that it doesn't actually matter to me. That's my primary case on the meaning of third parties. It's consistent with what Rightmove say in their letter. But it doesn't matter to me, because even if the claimants are right, third parties means any and all potential other parties whatsoever. The position would be this. Clause 22 has a prohibition, a general default prohibition on selling on or providing access to services to third parties. So that applies. There's then subject to obtaining written permission from Rightmove. So the starting point would be you're prohibited from reselling to all third parties. Now, in my submission, the claimants are not going to have any problem demonstrating that Rightmove permitted private landlords to be the clients of agents and to get onto the Rightmove platform. Because it's common ground that Rightmove allowed you to at least do that. If you're an agent, you could advertise on behalf of private landlords. So they're not going to have any problem demonstrating that Rightmove permitted them to do that. We wouldn't contest that Rightmove permitted them to do that. But they're still stuffed on commercial letting agents because they can't demonstrate anywhere in the documents that written permission was given by Rightmove to use its membership or its services to advertise properties on behalf of other agents. That permission was never given. So even if they're right that third parties means all third parties, on the facts, that's not a problem for me. Right, so I take the primary position on the basis of how Rightmove say their terms apply, and they say, well,
when you say on the facts, how do we know whether it is factually correct that there was written consent by Rightmove to BPG placing adverts on behalf of private landlords? I mean, that would be a factual inquiry that wasn't investigated before the judge. It would require evidence.
That's right, my lord. So the position would be if you were to determine that third parties in that clause meant all potential parties, there would then be the burden would then be on the claimants under clause 22 to show that it got permission to advertise on behalf of other agents.
that would be a very odd reading of clause 22. If third parties means everybody other than the member themselves, it would be saying, here are all the services, this is what you do, but actually membership doesn't entitle you to advertise on behalf of anybody. You've got to have written permission in relation to every single client or category of client.
Yes,
that would be an odd thing to find tucked away in clause 22, wouldn't it?
Well, the only way you get around that is saying clause 22 must be dealing with some other type of problem. It must be prohibiting some other problem. And the only explanation from the claimants is that it's prohibiting, that it's the services point we discussed.
No. I think the point is it means people other than the member or the member's client as defined. Because of course, if you look at the activity that we're concerned with, which, as you say, is very wide, it includes providing access to the services. Now, if it means what you said means, that means simply putting properties on the website, well, obviously, the member's going to do that on behalf of their clients. So it seems to be aimed at a category of third party who are not the member's clients. Of course, it's going to be doing that on behalf of its clients. Can't really be thought it needs written permission to do that, which suggests that third parties means people who are not the member or the client. And that, as I understand it, is the respondent's position. And given that client is widely defined as permitting commercial letting agents, this clause just doesn't bite, because it's not the activity that you say is prohibited isn't being conducted towards a third party. That, as I understand it, is the argument you have to make.
Yes, well in that scenario, it's difficult to think of a circumstance in which this company could provide access to something that Rightmove provides to a third party. That isn't the scenario we're considering in my submission, which is letting other agents get the service that it has as an agent on Rightmove. It's difficult to think of what other factual evil it might be provided. It seems to be common ground between us that the main, if not the only service that Rightmove provides is putting up properties on its platform. And the only people in my submission who are interested in that service are other potential clients of a member. That could be commercial agents or could be private landlords. If Clause 22 isn't dealing with this, it is, my submission, very difficult to work out what factual problem Rightmove is concerned about, apart from the re-sleeving problem, which the judge identified.
All right, thank you.
Well, those are the two main points I understand it dealt with by the claimants and their skeleton. The third point I was going to say was that Clause 22 is a new point which wasn't run below, and I've dealt with that. It obviously was run below. That was all I was going to say on the Rightmove terms. I was going to move on to ground 2, which is Zoopla.
Yeah.
Which you have at tab 22 of your bundle. It's the Zoopla terms. The issue on this is much shorter. There is no equivalent definition of your client in the Zoopla terms. It doesn't define your client as potentially including agents. So that quirk of the Rightmove terms doesn't arise on these terms. And the judge deals with this. Similar reasoning to the Rightmove terms. Essentially said there's no clearly expressed prohibition in these terms, and Zoopla could have made its terms clearer. And I've dealt with that process of reasoning in relation to Rightmove. In my submission, in the Zoopla terms, there is a very clearly expressed prohibition, which you have at clause 3.1 of the terms. That's on page 250. It starts at 3.1, pursuant to which the member, so any member of Zoopla, warrants and represents various things. And then over the page at 3.1.10, one of the warranties is that each of its branch offices will only upload details of properties they've received instructions for, specifically at each branch office location, that no branch office will upload details of properties originating from any other branch office location. It's particularly the second half of that clause that I rely on. As you'll see, as my Lord Justice Popplewell put to me earlier, that is actually, it's the Zoopla equivalent of the clause 11 of the Rightmove technical guidelines.
So I'm puzzled as to how you get anything out of this to help you, because surely this is, first of all, it's talking about physical branches, hence the reference to branch offices and to locations. Secondly, it's talking about branch offices of the member. So you take a member who has, let us say, for simplicity, 2 branch offices. Each of those must upload details of properties that they have themselves received and not ones received by the other branch office. That's what it's talking about, isn't it?
In my submission, it prohibits both. It prohibits the scenario you've posed to me, which is a, say, Foxton's Camden, posting properties on behalf of Foxton's Islington. That scenario, I accept that. But in my submission, it also covers what we're talking about, which is Foxton's Camden posting properties on behalf of some other estate agent based somewhere else in London.
But how does it apply in circumstances where it's all being done online because you just have an online business, particularly in circumstances where there's a specific definition of an online agent?
Well, Lord, I'm coming to that. I was going to take it in stages, which is the starting point of my submission is to deal with it as if we're dealing with a traditional agent, to work out what the terms apply, how the terms work with a traditional bricks and mortar estate agent, so Foxton's and Camden, how this term applies. Then I'll deal with whether it makes a difference that this company happened to be a website, if that's all right.
Okay, so the first stage is, well, this would stop Foxtons in Camden advertising the properties of Foxtons in Islington.
Exactly. Well, that certainly, my lord, but also on behalf of other agents.
Where'd you get that from?
Well, it's not branch office. In the second set part of the clause, no branch office will upload details of properties originating from any other branch office location. It doesn't specify branches of the particular member.
But then you're giving branch office a different meaning in each part of the clause, because no branch office will upload. That must mean a branch office of the member, mustn't it?
Yes, my lord.
And you say that any other branch office doesn't just mean branch office of a member, it means branch office of anyone. So you're giving branch office a different meaning in the two different parts of the clause, aren't you?
Well, the prohibition on what a member can do can only apply to by definition, can only apply to branch offices of a member, because that's where they provide their services.
Yes.
But it doesn't then specify any other branch office location of that member. It's sufficiently the words branch office. The prohibition applies to branch offices of the member, because the member is the only person with branch offices. But in my submission, it also prohibits them from placing adverts on behalf of branch offices of others.
Sorry, but we have to read the clause as a whole.
Yes.
It starts by saying each of its branch offices. So its
Yes.
must refer to the members.
Yes,
correct?
I accept that, my lord.
So it's the members' branch offices will only upload details of properties that they have received instructions for, specifically at each branch office location. So again, that must be each branch office location of the member.
I accept that.
And that no branch office, again, we're talking about the branch offices of the member, yes,
Yes.
will upload details of properties originating from any other branch office location. That must be any other branch office location of the member.
But that's where that's the point at which we've parted. I accept that the prohibition can only apply to branch offices of the member, because it's only the member that has branch offices. But the last reference, in my submission, is sufficiently wide. It's not defined. The last reference to branch office location is not defined specifically to those branch offices of the member. So it can catch the member's branch offices, but also branch offices of other agents.
So, as my Lord Justice Popplewell put to you, you are giving branch office and branch office location two different meanings in the same clause, which is never a good thing, a matter of contract interpretation.
Well, how I'd put it is the words branch office are on their own capable of catching both. And early on in the clause, obviously, it talks about its branch offices. So it's specifying the branch offices of the member. But of course, in the end of the clause, any other branch office location. It's not just the branch offices of that member, potentially other branch offices as well.
I mean, the short point, is this right, is you say, well, if they go to this trouble of prohibiting it as between different branches, it would be a bit rum if they weren't prohibiting it in relation to other agents.
That's exactly
that's the point.
Yeah.
The slight difficulty as a matter of interpretation is that obviously there's nothing in the contract about that, but it is, as you rightly say, trite to point out that it could have been easily rectified. So I understand that. But that essentially is the underlying point.
Well, it's a very short point on
Yeah,
Zoopla,
I understand.
which is if you have this prohibition on, as I say, have a bricks and mortar agent advertising properties on behalf of other agents, other branch office locations, whether they be their own or those of other agents, it makes no sense at all not to have that prohibition when you've got a web-based business.
So how does
We
it
haven't
work if it's a web-based business?
I was going to say, we haven't got to that yet. We were
Yeah,
just
yeah,
looking at the physical. We were just looking
Yes.
at physical branches and the possible difficulties with that. Now we're going to move into the world of the internet, and you're going to then translate that, as my lord asked. How do we how do we translate that into an internet service?
Well, the starting point of my submission is it would make no sense to treat web-based businesses differently, because the objection is the same in each case. It's other agents who are not themselves members of Zoopla, haven't paid the membership fees, using a member as a sleeve to gain access to Zoopla's platform. And it doesn't matter for that purpose if the agent in question operates its business through a website or operates its business through branches on the high street and a website, which is the case in something like Foxton's. In fact, that prohibition that we've just been looking at, if that was the case, could be easily circumvented. Other agents would simply sign up with a web-based...
But again,
Well, doesn't that-
in the case of Zoopla, we know even less about the commercial arrangements. I mean, the terms and conditions that we've been shown, we don't seem to have the membership application form if there is such a document in the Zoopla case. And we have no information at all about how their charging structure works. I mean, for all we know, I mean, you may tell me I'm completely wrong, but I haven't even seen anything that charges a membership fee. Maybe it's an entirely advertising-based business. We've got no idea, do we?
Well, I can deal with both those points, my lord. You're right, there should be an application form for Zoopla. It's called the order form in Zoopla's case, but I only have what's been disclosed to us by the claimants, and we're told they don't have the order form. So I only have what I have in the case of the Zoopla terms. Rightmove, I've got the application form and the terms. Zoopla, I don't. That's what happened to that. In terms of the charging structure, that is dealt with in the terms. At clause 3.4.8.
Thank you.
On page 251. So from time to time, Zoopla can increase the fees payable by the member. Following the assessment of Zoopla, the term number of properties displayed on its website, that's Zoopla's website, on behalf of the member has increased such the number of properties exceeds the average for members of similar type. And in assessing the number of properties, the applicable average explains how it does that. And for agents' properties, it would be on a per branch basis by reference to the geographical area. For developers, per development. And then for online agents, that's the only, as far as I can see, other reference to online agent in the terms. The only place where that defined term is used. Assessed by reference to the appropriate geographical area. So with both traditional agents and online agents, its starting point is to look at the coverage area of that member and to charge a fee according to that.
Isn't that clause against you? Because it recognises that for the bricks and mortar agencies, it makes sense to talk of branches, hence the reference to per branch basis. Whereas for an online agent, there's no reference to branches for the very obvious reason that they don't have physical branches.
I accept, of course, that online agent doesn't have physical branches, but the charging structure is the same, my lord, in both cases, by reference to the geographical area in which that agent operates. So it adopts the same charging structure for both a traditional agent and an online agent. So it treats them the same in that respect.
Yes, but in the case of the online agent, I mean, you're right, of course, it does use the words by reference to appropriate geographical areas rather than an appropriate geographical area. But I mean, it's recognising the reality that there is no geography on the internet, isn't it? I mean, what it's saying is that we recognise that online agents notionally can cover the entirety of the UK, and we will proceed as we consider appropriate.
Well, I've got no. It is odd, my suspicion, that in the case of a website, the charging structure is dealt with by reference to geographical location. I don't know how that's done in practice, but that's the basis on which Zoopla says it will approach charging the same way as it would for another agent.
But more generally, isn't this the answer to the so-called sleeving problem? Is that their charging structure looks, so far as one can tell from this, it's all incomplete, as though at bottom it's calculated on roughly the number of properties they would expect to be marketed by reference to the client profile, whether it's the branch or the website or whatever. And if the number of properties increases, they've got the right to increase the charges. So that if another commercial agent who's not a member is using a member, either that will involve the member advertising more properties than they're notionally being charged for, in which case they can be increased, or it won't, so that the charging structure, which was originally applied to the member, will still remain valid.
Yeah, yes, well, the way you would deal with it if you had a huge influx onto the websites, you would increase the charges. But it's the point we discussed before. So I think it's not a sensible way for Zoopla to go about it, because it's not incentivizing other agents to be members, and you'd have to charge a exponentially increasing amount to one agent, which seems like an odd way of going about your business.
No, right. If you forget your extreme example of the one agent in the Hebrides, why is that unrealistic? You find that a single local estate agent has many more properties being put on the site than one would expect from such a local agent, and it turns out that that's because it's taking referrals from clients who are themselves letting agents. So you increase the fee. What's the problem?
Yes, it's one remedy which Zoopla has if that kind of conduct is occurring. It obviously imposes a burden on Zoopla then to monitor what's going on, to spot that agent's out of step with the remainder of the agents.
Well, presumably they're doing that all the time. That's the whole point of 3.4.8.
Yeah, well, it's certainly possible for them to do that. My suggestion simply would be much a simpler system would just be to have encourage as many members to sign up to the Zoopla platform to increase its market share as possible. Once all agents in the country.
How can we take a view on what's a sensible business model for Rightmove and Zoopla? I mean, they may have, for all we know, they may have slightly different business models, but I mean, it's not for us to assess what's the best business model for them to adopt. I mean, there may be, as we've already discussed, different ways to approach this. I mean, as we've already touched on, one way might be to get most of their income from advertising and only a small amount from fees, or maybe it suits them to get a lot from fees. But I mean, that's up to them, isn't it?
It is up there. Well, we know what they say. They make their position quite clear that how their model works, which they've set out. Which is that
but your premise is that increasing the number of members increases Zoopla's or Rightmove's market share. I have to say, I regard that as not self-evident at all. Their market, their success as a website may be very largely dependent simply on the number of properties that they have being advertised, because that's what attracts others to use it. If it seems to be where all the purchasers are going to go because it's got a very large number of properties for sale or for let, that's obviously a very important part of the business model. So I can quite see that they might be driven by the number of properties rather than the number of members. But it doesn't follow that it's therefore in their interest to have a greater number of members that they have, if the properties are coming through the members that they have because selling agents are clients of those members.
Well, that seems to be the position they take, and they obviously emphasise membership revenue. And there's the second point we discussed in relation to Rightmove, which is obviously if you are deciding what agents use your platform, you have control over those agents. You can decide who's part of your club and who's not. And of course, if those agents are actually letting other agents get access to their membership, you lose that power of veto of your membership. So it's a combination of things. I say the loss of membership revenue is not attractive.
But I'm not sure I quite understand about it being a club, which is not something that I regard as an apt description to a business venture, because there are warranties that are given by the members in relation to the members' clients. You have all sorts of warranties, so that in terms of what you describe as control, by which I take it you mean business practices or matters of that nature, I'm not quite sure that there's any provision that shows you've got a lesser degree of control.
Well, control in the sense of deciding which agents are going to be, when they send in your application form, you decide to accept. And they may have various reasons for deciding which agent is an appropriate agent to be a member of their platform, which isn't. Now, in my estimation, that's an attraction to Zoopla. It has control over its membership of agents in that way. And you're absolutely right to say, of course, those agents have to give warranties about what their clients can do. That's some protection for Zoopla. So it has those warranties, but it also has the protection of deciding which agents it admits or not. There are two protections. And on the claimant's interpretation, you lose that second protection. You just have a member who basically then has free discretion to decide who it allows access to the platform for, who it allows to benefit from its membership. And true enough, you might be able to sue them for breach of warranty, but if they disappear or go bankrupt, you can't. And you lose control over the class of users, the users of your website.
So you'll protect the reputational risk.
Exactly.
From not having the dodgy business of popplewelllettings.com using your site.
Well, I wouldn't speculate on that. But it's twofold. It's a financial incentive, I say, because obviously membership revenue, maybe there are other streams of revenue, but membership revenue is one. And secondly, it's a practical control point about who your members are and your control over them. So those are it's the same point, I say, in relation to both Rightmove and Zoopla. Those are their reasons for for not wanting agents to be able to re-sleeve onto their platform in this way. Well, Lords, on the Zoopla terms, just pick up a couple of further points. Really, it just comes down to, as well, Lord raised something earlier, can you treat a website where a member happens to operate through a website as a branch office or branch office location for the purpose of this clause? And the claimants say, well, as a matter of language, that's not possible. Now, my submission is possible as a matter of language. And you can see that from the Rightmove application form, just using this to illustrate the point, I'm not saying it applies to the Zoopla terms. You have it, tab 19 of your bundle. This is the form submitted by the claimants. You can see from this how they treated their own website when they applied for membership of Rightmove. So at the start, the company name is mylet.com, key contact or branch or office manager, Mr. Butcher, the first respondent. Registered office is given. The branch name to appear on the website is mylet.com. The number of branches or offices is down the bottom. That first box within the company is 1. Box 2, you pay a per branch membership, and again the number of branches is 1. And then at the bottom of box 5, you write a photograph of your office or branch and a description of the company it services to include on your branch or office page on the website. So certainly when it was applying for Rightmove membership, this company had no problem at all in treating its website as the equivalent of a branch of a traditional agent. That's also repeated in Mr. Butcher's statement, paragraph
It
30.
might be said they didn't have any alternative because the membership form they were filling in was all expressed by reference to branches and offices. There wasn't an option to fill in, as far as we know, an alternative membership application for online businesses only. So they gave the best answers they could in those circumstances.
True, my lord, but my point on that is simply they didn't seem to see a problem with putting forward the website of the company as a branch, or say this doesn't apply to us, or we don't have any branches. We can't possibly say that a website constitutes a branch. That's my submission on that point. It didn't seem to be a problem for the claimants when it didn't occur to them when
But we come back to the difficulties we have in not really knowing very much about Zoopla's charging structure. We can infer from this that the charging structure of Rightmove was on a per branch basis, and they treated a website as a branch for the purposes of that pricing. But do we know, for example, that the Zoopla charging structure took a similar view? Could it be, so far as we know, that it charged quite separately, in the one case by reference to physical branches where there were physical branches, and by reference to a different charging structure which it calculated referable to websites?
Apart from the clause I've taken you to, well, there's 3.4.8 of the Zoopla terms. That's the only clause I know of that deals. It's the only information we have about how they charge.
Which does suggest that they approached them differently. They had different charging criteria for physical branches and for websites, albeit that for websites they used a paradigm of a geographical location, whatever that might mean for a website.
It's certainly true they distinguish between them in that clause, but as we've discussed, the charging structures, I would say, is the same by reference to geographical location, although they spell out the different types of potential member, being an agent and developer and an online agent. As I say, that's the only place in the clause that you get that distinction. The rest of the terms, the Zoopla terms, although there is the definition of online agent, they don't distinguish between the two. So what you might expect it to find is saying, well, actually, obviously, online agents are very different. These prohibitions apply to online agents. These prohibitions apply to bricks and mortars agents. You don't have that. I'll show you just a couple of points very quickly, if I may. The first one is 3.1. It's the start of the section on obligations, which applies generally to a member, and then there's a whole series of warranties and representations given, which I've taken you to 3.1.10. So all of those obligations are meant to apply generally to a member of Zoopla, which is defined as an agent or a developer, simply. It doesn't specify that some of these apply to bricks and mortars agents and some of them apply to online agents. All of these obligations have to apply to a member of Zoopla, and that includes 3.1.10, which is the clause that I rely on. There are other examples. So 3.3.3, which is a clause my learned friend relies on. Zoopla reserves the right to charge the member additional fees in the manner it deems appropriate on a per-property basis if Zoopla has reason to believe the content uploaded by any of the members' branch offices is in breach of 3.1.10. Again,
Sorry, where are you reading from?
sorry, my lord, 3.3.3, page 251.
3.3.3.
Yes.
Yeah.
Again, it's reference to a member. And at the bottom of that page, 3.4.10, it's not as important a clause, but it still illustrates my point. The last two lines, a member shall maintain a valid working email address for each of its branch offices and shall immediately notify the company of any change of email address.
So it's my fault. Which clause are we on now?
Sorry, I moved too quickly. 3.4.10 at the bottom of the page. So it's a trifling obligation in a way. It's an obligation to provide a valid email address and keep that updated. But it applies to each member. So it would be odd in my submission if, for some reason, that only applied to bricks and mortar agents, but not to web agents. The terms and conditions treat the two the same, despite the fact that, as you've seen, there is a definition of online agent. That's the last point I deal with on Zoopla, my lord, is the definition of online agent itself, which you have seen, but is it page 249. That's the estate agent, lettings agent.
I'm sorry,
Yes.
Mr. Lawson. I don't criticise you for making your submissions briefly. That's a virtue. However, sometimes your economy means that I'm struggling to get your point, and that's my fault, I'm sure, that's yours. So in this case, you draw our attention to 3.3.3 and 3.4.10.
Yes.
And I've seen what they say, but I haven't quite got my head around why you say they assist you.
Apologise, my lord. My point is that both terms, the obligations they impose are imposed by reference to a member of Zoopla, generally, which is not a term that draws a distinction in my submission between members who happen to be traditional bricks and mortar agents and members who happen to be online agents. So my submission is simply these terms, all the obligations they impose, are intended to apply to all members of Zoopla. And if the claimants were right that web agents were to be treated differently, you would expect the terms to say only traditional physical branch agents need to comply with these.
But forgive me, I may have been very dense here, but let's take 3.4.10 by way of example. This explicitly refers to emails and electronic media. It's electronic means of communication. And so it's something that is inherently capable of applying to an online business as well as a bricks and mortar business. Why does it help you to show us a clause that is, on its express wording, capable of applying to both? How does that help us when it comes to construing a clause 3.1.10, which on its face is only applicable to bricks and mortar?
Well, my submission is that the terms don't distinguish in terms of membership generally. And so the position taken in 3.4.8 and 3.4.10, my submission is the same at 3.1.10. So the starting point is this is an obligation of a member, so all members in my and that term, Zoopla, you would expect, thinks applies to all members. It would be odd if you had 3.1.10, which is an obligation of all members, which only applied to some and couldn't be satisfied by online agents.
As I understand your point on 3.4.10, what it's dealing with is enabling Zoopla to have contact details in order to provide information and so on. And it requires the member to maintain and notify a valid working email address for each of its branch offices.
Yes.
Now, branch offices may not themselves, strictly speaking, have a separate email address, but what that obviously means, you say, is the email of a contact at each of the branch offices.
They could have.
They could have, but they won't necessarily have. But it's contact details of at least one per branch, and you say that must mean, when it says email address for each of its branch offices, must, in the case of an online agent, mean an email address for someone who operates the website.
Yes, Malone puts the point much more eloquently and better than I did. Both 3.4.10, 3.3.3 not only refer to members, they also refer to branch offices. So in my submission, it'd be odd to have a clause that imposes an obligation on a member and their branch office. If that wasn't meant to apply to a web business, it's why require, in the case of 3.4.10, why require a traditional agent with branch offices or physical offices to provide an email address, but not require an online agent? The answer in my submission is that branch office must be capable of being a website. If you happen to be an online agent, that is your branch office. Instead of having a high street presence where people walk in the door, your website is your branch.
Yes, but isn't the clause disjunctive? Because what it says is that Zoopla, the group companies, may, unless otherwise agreed in writing by Zoopla member, contact the member by electronic means, including email and electronic media. So that's saying you can use electronic means. And then it goes on to say, and the member shall maintain a valid working email address for each of its branch offices and shall immediately notify the company of any change of email addresses. Well, if it doesn't have a physical branch office, it plainly doesn't mean that it can't provide an email address, because the general wording beforehand makes it plain that Zoopla can communicate with you by email.
Yes, well, the first part of the clause makes that plain. It's the second part that I rely on, which does, in my submission, impose an obligation to maintain a valid working email address. And it would be odd, simply, in my submission, if that was only an obligation of traditional agents, as opposed to all members of Zoopla, whether traditional or not.
Yeah, okay, thank you.
Well, very quickly, the last point is the definition of online agent, which is that an estate agent, lettings agent, and in Scotland, solicitor agent, or commercial property agent that operates primarily via website rather than a physical branch and does not operate through a local office network. You have that, I should have taken to you first, but page 249, the terms and the definition.
Yeah.
Now, in my submission, it's not a problem for me, because I'm not suggesting that, as a matter of fact, this company had physical branches. I accept it was an online agent within this definition. I'm simply saying that when you come to apply other parts of the clauses, you treat the website as if it was a branch for the purposes of those other clauses. I'm not saying it actually had branches, and therefore this is an inapt way of describing an online agent. So that's the point on the definition. Otherwise, the third ground is the clause 6 of the SPA. So if we succeed on grounds 1 and 2, my submission there will be a breach of warranty, which otherwise sounds in damages, and the respondents then seek to avoid liability by relying on the exclusions of the limitation clauses in clause 6. the starting point in my submission is actually clause 5, because clause 5 and 6 are linked provisions. And you have that tab 17 of your bundle at page 192. So clause 5 sets out the warranties and the basis of liability of the sellers for breach of warranty. So at 5.1, the warrantors warrant and represent the purchasers, subject to clause 5.2, that each warranty is true, complete, accurate, and not misleading at the date of this agreement. And then all the warranties are set out in Schedule 3, including one that we rely on. 5.2, the warranties are subject only to any matter which is fully, fairly, and specifically disclosed in the contractual disclosure letter, and you have that disclosure letter behind tab 18, or the provisions, and the provisions of clause 6. And then 5.3, the warrantors acknowledge that the purchasers have been induced to enter into this agreement and are entering into it in reliance on the warranties, which have also been given as representations, which is an important point. These warranties are also contractual representations. 5.4 and 5.5 we don't need to worry about for present purposes. That's the basis of liability for breach of warranty. And then you have clause 6, limitations on that liability. And the 3 limitations are set out in the following provisions. The first is a limit that you won't bring any claims until the aggregate value exceeds £1,000. The second one, there's a limitation, like a price cap basically to the purchase price. And then the third one is one that the respondents rely on. No claim for breach of warranties otherwise in relation to taxation shall be made unless the claim has been notified in writing to the warrantors within 6 months of the completion date. Now, I accept we didn't do that. The completion date was the 20th of February 2017, so the notification deadline in that clause would be the 20th of August 2017. But in my submission, it doesn't matter, because we are entitled to rely on the proviso. We say we didn't know by that date anyway. This only became apparent in August 18, a year later, when we were suspended by Rightmove. Then notice was given on the 28th of August 2018. And you have that at tab 7, your supplemental bundle, page 245. We don't need to turn it up. My submission is it doesn't matter that we missed the deadline, because we're entitled to rely on the proviso in 6.2, which is that none of the limitations contained in clause 6 apply to any claim under the warranties where there has been fraud or negligent non-disclosure. And then the clause goes on to deal with the point on the taxation warranties. Now, just unpacking that for a moment, the claimants say in their skeleton, they refer repeatedly to fraudulent or negligent non-disclosure. In my submission, that's wrong and inaccurate. It's not what clause 6.2 says. What it talks about is fraud or negligent non-disclosure. It's not two types of non-disclosure, fraudulent non-disclosure and negligent non-disclosure. It's fraud or negligent non-disclosure. Now, the reference to fraud is, in my submission, easily explicable and makes sense. Because I showed, my lords, clause 5.3 of this contract says that each of the warranties are also given as representations. So if the claimants knew that one of those representations was untrue when made, you would have a case in fraud, and this provision would apply. So that's what the reference to fraud in my submission is doing in that clause, and that's the scenario in which it would apply. We can put that to one side. The words then that really concern us are negligent non-disclosure, specifically. Now, in my submission, that is an odd choice of words, which at first sight seems out of place. It's common ground between us that in this contract, the claimants had no positive duty of disclosure under the SPA. That's expressly accepted at paragraph 90 of my learned friend skeleton. Now, in my submission, it makes no sense in that context to talk about a culpable non-disclosure by the claimants, or still less a negligent non-disclosure, when you have no positive duty to make disclosure. So we need to try and attribute some meaning to that provision. What we do have is an obligation to provide a disclosure letter, which, as I said, is at tab 18 of your bundle. And the only place in this whole contract where the contract contemplates any disclosure being made is in the disclosure letter. I showed you clause 5.2.1. The warranties are subject to matters fully, fairly, and specifically disclosed in the disclosure letter. So, well, in my submission, when one sees clause 6.2 and the reference to negligent non-disclosure, the appropriate way of reading it is a non-disclosure in the contractual disclosure letter, because that's the only place in the contract where we get into the situation of claimants having to disclose or disclosing any information to us. So that's how you make sense of that provision.
Well, I think I get the point you're making, but there's no obligation on the claimants to put things in the disclosure letter either.
Yes, well, I should be clear. I accept that. I accept there's no obligation or positive obligation to disclose. What I say is, to try and make sense of this provision, what you do have is an obligation to provide the disclosure letter, and the contract contemplates disclosures being made as the only place in the contract where it contemplates disclosures being made in the contractual disclosure letter. I accept there's no positive obligation on claimants to disclose.
Yes, but I thought I'd understood the point you were to be making was to say, well, at first blush, the word negligent is odd because you can only have negligence if there's a duty. Where comes the duty of disclosure? You say common ground, no general duty of disclosure, and you then seek to explain this oddity by saying, but there was a disclosure letter. But how does it explain the oddity if there's no duty to put things in the disclosure letter? The oddity remains.
My Lord, I agree that the most natural and expected meaning of negligent non-disclosure is a negligent failure to comply with the duty to disclosure, but that doesn't arise on either party's case. One then needs to attribute some meaning to the clause. In my submission, it makes sense to talk about a careless failure to put matters in a disclosure letter, which the contract contemplates will be provided, more so than it does to talk about a negligent failure to disclose information at some other point, unspecified point, which you had no obligation to provide. So it's in trying to make sense of this rather unusual provision. I say my interpretation makes more sense because the contract does contemplate disclosure in a disclosure letter than it does on my learned friend's case. I accept there's no duty to disclose in either case. Whereas that's the position as a matter of language. It's my submission. My interpretation makes sense of, or some sense of, this provision. Firstly, as I showed you, the context is it's a limitation on liability for breach of warranty. Specifically, it's not a wider limitation clause. And of course, in the context of a breach of warranty claim, I'd simply have to establish the warranty was given and it was breached. Reliance isn't a part of the cause of action. So in most breach of warranty claims, pre-contractual, the fact that the claimant had disclosed a matter at some point in the pre-contractual negotiations wouldn't be relevant. If a warranty was given later on in the contract and it was breached, you would have a claim for breach of warranty. In any event, the warranties post-date the pre-contractual negotiations. So the whole point of getting the warranty is one doesn't have to worry about the pre-contractual negotiations. I've got a warranty. They promised that the state of affairs was true and it's false. So disclosure...
Yeah, that tells you whether there's been a breach or not.
Yes.
It doesn't tell you whether you should disapply the caps on liability for the breach, which not only involve a time bar, but what may have been quite important to the parties in this case, where the value was not huge compared to some SPAs. It's limited to the amount of the prize.
Yes, Mark.
So I'm not sure your submission gains anything by identifying that what is relevant to whether there is a breach of the warranty or not.
Well, the submission is simply that when we're talking about liability for breach of warranty, it would make sense to talk about disclosures in a disclosure letter, because classically that is if you're bringing a claim or if you're trying to resist a claim.
Yes, and the point I'm putting to you is that may be so if what one's trying to identify is whether or not there has been a breach of a warranty. This clause isn't dealing with whether there has been a breach of warranty, it's dealing with the consequences.
No.
And I don't really understand how your point translates from the one to the other. That's the difficulty I'm having.
All I'm saying is that is the context of it, where one is talking about disclosures in the disclosure letter, and to try and work out what disclosure this clause is talking about. It would make sense that it would be in the disclosure letter because we have one, and that's part of the contract, and that's where disclosures would be expected. That's the background. I totally accept it's dealing with the consequences as opposed to establishing the breach itself. It also has the attraction of simplicity. In order to establish if 6.2 applies, one simply looks at the disclosure letter. Has the relevant matter been disclosed? And was the failure to include that matter careless or not? Was it a negligent failure? So that's very simple.
All of that dances round the point of the clause, which is to limit claims to a particular time period. And you can't make a claim if it's more than 6 months, unless. So it's an exclusion to what is otherwise a cap. And the reason that you have this sort of exclusion is where things have occurred which in this case, your clients don't know about. So they can say, well, it would be unfair for this to apply to me because I didn't know about it. So in those circumstances, why would you want to limit it to the disclosure letter? You then run the risk that actually there was something that you were told about and therefore you knew about it, but because it wasn't in the disclosure letter, on that case, there would then be, you would then know about it and have the advantage of getting around the 6-month time period, which would be a very odd result, wouldn't it?
Well, the number of points. Firstly, is that it's an exception to 3 limitations. So it's not an exception that applies only to the time bar. It obviously applies to different types of limitations. So it's not, in my submission, concerned exclusively with the 6 months.
No, but we're focusing on that because that's the point that's arisen.
Of course. But my submission is that obviously that might make more sense if you only had a time bar and an exclusion to the time bar. But it's an exception that applies, if we were within 6 months, but there was an issue about the quantum, this would continue to apply. So it's not specifically about time. Secondly, if that was the target of the clause, then it would make more sense in my submission to focus on the defendants, or the buyers, the buyer's knowledge, whether it was aware of a particular matter. And we often see clauses like that, and there's one in the Hutt Group case, one of the authorities cited, which talks about when the defendant or when the claimant was aware of the relevant matter and what type of knowledge suits for that purpose. But this clause focuses...
But then we're straying down the line of, well, it could have been written differently.
I'll focus on the words then. Well, I take that point. The point is the words used are...
you're limiting, you want to limit negligent non-disclosure. You, as a matter of interpretation, you say the court should, well, you wouldn't say write in, but
no.
One way of putting it would be to write in or negligent non-disclosure in the disclosure letter.
Yes.
Or rising out of the disclosure letter. So you want to limit the non-disclosure to that.
Yes. Well.
And I'm saying, well, is that actually purposive if you consider what the clause is trying to do? Because you run the risk that it would then be something that you did know about because it was disclosed, but because it wasn't in the letter, you get round the cap or the time bar.
Well, the first point, writing in, I don't accept it's rewriting the contract. So the claimant says, questions.
Well,
does non-disclosure mean disclosure in some unspecified general sense, or does it mean disclosure in the contractual disclosure letter? There's 2 ways of reading the clause.
Okay.
In terms of the purpose of it, obviously that letter serves 2 purposes. The disclosure letter. Firstly, if you disclose matters in the letter, that limits the scope of the warranty. But also, disclosure letter is to the buyer's advantage. The whole point is to get a letter that sets out matters that you might be concerned about, potential breaches of warranty. So in my submission, what this clause does is it incentivizes the seller to make disclosures in the contractual disclosure letter, which makes perfect commercial sense, saying if you want to rely on this limitation clause, you need to make sure that you disclose or anything that might concern us in the disclosure letter, rather than keeping quiet about it in the hope that 6 months might pass and we don't find out about it, which is what we say happened on the facts.
Sorry, why is the incentive not provided by clause 5.2.1? Because that accepts from the warranties matters fully, fairly and specifically disclosed in the disclosure letter. So you know, as vendor, that everything you put in the disclosure letter, you're immunising yourself from a claim for breach of warranty.
Yes.
Why is that not a full and adequate incentive?
But you might have a situation that I accept that, Lord. You might have a situation, however, because of course the disclosure letter arrives before the contract, where you put some matter in there which spooks the horses, which puts some matter in there which makes the buyer say, actually, that's so serious. You're not giving me a warranty about that. I'm not going to buy at all because of that issue, if I've seen that in the disclosure letter. So there's an incentive.
So I'm baffled by that submission. We know this contract was concluded. So how can we hypothesise a world in which it wasn't concluded because of something that was put in a disclosure letter?
Well, I'm not saying that in the facts. I'm saying try and make sense of how the clause might apply in various scenarios. I'm saying it's possible you could have a situation where a seller made a calculated decision to keep quiet about a problem rather than put it in the disclosure letter, because they thought if they did so, that might put the buyer.
If they're going to make that decision, then it's not going to be in disclosure elsewhere. The problem only arises on the supposition that there is disclosure outside the disclosure letter. If it's completely kept quiet, subject to any claim for fraud, we don't get into that question.
Yes, well, that's right. There'd be a debate about what would constitute sufficient disclosure. Something referred to in passing in the pre-contractual negotiations. You wouldn't get into the scenario if there was full and frank disclosure of the issue, I accept. But one only gets into 6.2 at all if there's been non-disclosure in the disclosure letter. So that's why I said at the start they're linked clauses. They only apply if there was disclosure in the disclosure letter, then the warranty wouldn't apply in 5.2. So that's the starting point, clause 5. If there's been non-disclosure in the disclosure letter, you then get into the question of does the exception apply? And that, in my submission, could explain why the reference is to negligent non-disclosure as opposed to just non-disclosure. Because the only possible scenario you get in 6.2 is if there has been non-disclosure already in the disclosure letter. And then the question is, well, was that careless non-disclosure or was that something else? And that goes to my lawyer's point about what was the purpose of this clause. I suppose they're linked in that way. It's only if you don't have a disclosure in the disclosure letter that 6.2 comes into play.
Yeah, the factual hypothesis on which this argument matters is full disclosure was in fact made. Everybody knew what the true position was, but it didn't go into the disclosure letter.
Yes.
Which, on that hypothesis, would necessarily be negligent.
Exactly.
So what we're testing, really, if we're looking at the purposive aspect of the clause, is was it a situation in which full disclosure has been made and everybody knows what the true position is, but it didn't go into the disclosure letter?
Yes.
And you say, well, 6.2 doesn't that does disapply the limits in those circumstances.
Yes, well, I would say it'd be straightforward that if you knew about a matter and had mentioned it previously, it would be straightforward to put it in the disclosure letter. It's obviously careless not to mention it in the formal document.
Yeah, but notwithstanding everybody knew what the true position was, that means you lose the protection of the numerical cap and the time limits.
Yes, well, Lord discuss that's as I say, that's always the case in a breach of warranty claim, excluding the cap for a moment, that you could make full disclosure of something at some point in the pre-contractual negotiations, and then give a warranty later, and I'm entitled to rely on the warranty.
Yes, but the warranties themselves and a limit on
yes,
restrictions on the liability which follows from a breach are two quite separate concepts, aren't they?
Yes,
and
no, acceptable.
And they may be important.
That covers the clause itself. Very quickly, I deal with the judge's reasoning, which is at paragraph 70 of the judgment. What the judge said, 70, my lord, which said what the parties were trying to say was that the purchaser would not be prevented from bringing a late claim if the reason it was brought late was because of concealment by the sellers of facts and matters essential to the decision or knowledge necessary to enable them to bring a claim, or to put it another way, because those facts and matters ought properly to have been, but were not disclosed to them. There's 2 points there. Firstly, the clause doesn't talk about concealment or deliberate concealment.
No, I think that's, I mean, I read that as a poor choice of language by the judge, because concealment can sometimes be taken to be a deliberate act. What he meant, I have assumed, was that something was not, some information was not provided by the sellers, and that is quite capable of being inadvertent, just as a matter of law, deliberate concealment can, in an extreme case, also be inadvertent, notwithstanding the use of the word deliberate. So I think, to be fair to the judge, whilst it is a poor choice of words, that's what I took him to be saying. You're quite right, concealment isn't there, but if you widen that to encompass inadvertent concealment, that something was, for whatever reason, not passed on, could have just been a mistake, negligence, whatever, then I think that's what he was meaning.
Well, in that case, that would deal with the question of whether it's concealment and that point.
Yeah.
The second point is because those facts, he says, point is because those facts must ought properly to have been, but were not disclosed to them. And that's the point we've covered. There is no positive duty to disclose. So that his interpretation would make sense if there was a positive duty of disclosure, but there isn't one. In fact, the judge goes on at paragraph 72 to say he actually recognises it's not possible to point to any duty that might be relevant to an assertion of negligence on any party to disclose anything. All that can be said is that if a warranty claim is to be avoided, facts and matters must be disclosed in the disclosure letter to the requisite standard. That's our case. The only place where this contract contemplates any disclosure is in the letter.
Yes, paragraph 70, the judge seems to be linking the matters that are not disclosed with the ability to bring the claim in the context of the time bar. But speaking for myself, I have some difficulty with that because 6.2 isn't only concerned with time bar.
Exactly.
It's concerned with the cap as well.
Exactly. Well, the only other point raised by the judge at paragraph 72 is that 6.2 does not refer expressly to the disclosure letter. We've covered that. In my submission, can be read either way. Disclosure in the disclosure letter or disclosure in some other place. The only other point...
Sorry, where,
sorry, my lord.
Where's that? Where are you referring to in the judgment?
Paragraph 72 goes over the page. In reaching this view, I rely on the fact...
the last few words, nor is
yes.
reference made to the DA.
Yes, exactly. So the judge takes that as an important point. My submission is not. You can read the clause as a gloss. It's either talking about non-disclosure in the disclosure letter, or it's talking about non-disclosure at some other time. The fact that it doesn't refer to the words disclosure letter is not determinative in my submission of the construction. The only other point dealt with...
Well, that's simply putting another way the point you made to me when you declined my invitation, suggesting that you were rewriting the provision by adding in a reference to the disclosure.
It is, exactly. That's why I say, the claimants say this is rewriting the clause. I say it's not rewriting, it's just determining the meaning of the words non-disclosure. It's not rewriting, it's interpretation. Well, the last point is...
The way the point might be put is that this agreement, as is common, is careful to use defined terms when defined terms are necessary. A disclosure letter is a defined term. So that a reference to something which is in language otherwise than a defined term, i.e. simply disclosure, is perhaps to be taken to be something other than disclosure in the form of a defined term.
Yes, well, you could put it that way. My answer to that is that the answer is that clause 5 and 6 I've showed you. Clause 5 talks about disclosure in the disclosure letter, and 6 is a linked provision, so it would make sense in my submission in that context for the words non-disclosure in clause 6 to be talking about non-disclosure in the disclosure letter. The draftsman might equally have thought, I don't need to spell it out in clause 6 as well, because it's clear from clause 5.
Yes. Well, then we go back to the same point. Clause 5 defines the scope of the warranties.
It
clause
does.
6 limits the consequences of a breach.
Exactly. I accept they're separate, but they're obviously they're two linked provisions of the contract. My only submission on that. My lords, the last point is contra preferentum. In my submission,
has there been a contractual dispute in the last 20 years decided by the principle of contra preferentum? I mean, I'm not aware of one, and I'd be very surprised if this appeal turned on contra preferentum. By all means, outline your point, but certainly speaking for myself, I'm sceptical as to the how far this goes, put it that way.
Well, I was going to make the point quickly in any event that there has been a dispute, which is the authority we cite, which is the Hutt Group case, Newbar Coulson, judgment of Lord Justice Briggs, as the M was, where he explains this principle continues to apply in the context of exclusion clauses, that contrary to what my learned friend says, it has absolutely nothing to do with whether you're the profferens of the clause of the party seeking to rely on it. It applies because it's an exclusion clause, and parties aren't likely to be taken up to have given up rights in their contract. And he goes on to say, on the facts of that case, his conclusions are reinforced by the application of the rule. So that's the case that we rely on, which you have at tab 3 of your bundle. My short point on it is that my submission, the highest claimants could put their case on this clause, is there is some ambiguity. The words negligent non-disclosure in this context are unusual words, which could be read in different ways. So there is some doubt, ambiguity, or uncertainty as to what the drafter of this clause was trying to achieve. Now, in those submissions, and that's clear from the judgment, when the judge talks about what the parties were trying to say, instead of what they actually said, the judge was struggling to reconcile this language because it was ambiguous and unclear. The claimants in their skeleton at paragraph 92 actually say that the concept of negligent non-disclosure is inherently meaningless. In my submission, that's a rather bad start for a submission that this is clear and unequivocal. It's an inherently meaningless phrase in this limitation clause. So against that background, I simply say that if there is doubt or ambiguity, one should apply contra preferendum to split the difference between the parties. It's a limitation clause and it should be construed narrowly. That's my submission.
But it's not a limitation.
Well,
it's an exception to a limitation. It's the very opposite.
yes.
Well, the point taken by my learned friend in skeleton, my submission, it's artificial to focus on the exception. The limitation is clause 6 in my submission as a whole, and to work out the scope of that limitation when it applies, one needs to read clause 6.1 and clause 6.2, which includes the exception. So to work out the scope of application of this limitation clause, that includes clause 6.2.
But however you express it, your construction gives a greater strictness to the limitation, to the exclusion. It makes the exclusion or the limitation more onerous. So I don't really see how contra preferentum helps you.
My construction makes the exclusion clause narrower in the sense of the claimant's ability to escape liability for breach of warranty. If relevant matters had to be disclosed in the disclosure letter, as opposed to in a wider disclosure that they could rely on. I accept it makes the proviso that I rely on wider. The proviso that I rely on would apply in more cases, perhaps. If we're only talking about a disclosure in the disclosure letter. But it makes the limitation as a whole narrower in my submission, to prefer my construction to my learned friends. Well, unless I can assist you further, those are my submissions on the 3 grounds.
Well, thank you very much, Mr. Dawson. I haven't got any questions. We've asked such questions as we've gone along.
I'll go for a moment.
Yes, Ms. Gookin. I should say that I received, I think it was on Tuesday, that the copy of your skeleton, it says with corrections.
Yes,
So that's the one that I have marked up.
I'm grateful, my lords, and apologies for those. It was just correcting an unpardonable number of typographical errors, which I thought might inhibit understanding of it.
One of them was a no in the wrong place.
Yes, that's perhaps the most consequential.
Never a good start.
Indeed.
Yeah.
My lords, I'll start, if I may, with some introductory submissions and then address each of the 3 grounds in turn. My lords, the overriding issue in relation to grounds 1 and 2 is whether Rightmove and Zoopla's terms contained an express term that prohibits the company, being a member, from placing adverts on behalf of other commercial lettings agents. I say express term deliberately because my learned friend doesn't suggest that there is an implied term. So the starting point, my lords, in hunting for this express term is the fact that there is no express wording in the Rightmove terms or the Zoopla terms with that effect. There are no contractual words that state a member shall not place adverts on behalf of another commercial agent. There's no contractual wording that states a member may not have a commercial letting agent as a client. And there are no words that limit what services a member may provide to a commercial lettings agent or indeed any other of the member's clients. So the judge memorably described this, my lords, this absence of express wording as an inconvenient truth for the defendants and for my learned friend. This inconvenient truth exists notwithstanding the facts that my learned friend says and has laboured to persuade my lords this morning that this would be a clause of vital commercial importance to Rightmove and Zoopla, and it would have been, as the judge below said, extremely easy for the restriction to be put in place and thus put the point beyond peradventure. And as I'll come to, my lords, this isn't the sort of casual submission one often hears that, oh well, if that's what they meant, they'd have just said so. That is a submission often heard and it cuts both ways. But what we'll see on these terms is that all the pieces were in place within the terms and conditions by way of definitions to include this restriction if it had been objectively intended. My learned friend's other great difficulty is that the Rightmove terms expressly permit members to list properties on behalf of commercial lettings agents. My lords have seen that the members, in their agreement with Rightmove, give a warranty that, quotes, your client does operate or carry on business as an agent, developer, or landlord. An agent is defined as a person primarily in the business of selling or letting residential or commercial properties or land on behalf of multiple unrelated third parties. So there's an express warranty which goes directly against the prohibition my learned friend says exists as an express term. So, my lords, since neither the Rightmove nor the Zoopla terms contain this clear and express prohibition, and indeed since the Rightmove terms contain a contrary express warranty, the defendants are forced to rely upon a number of what I would submit are strained and unnatural interpretations of various other provisions. My learned friend had relied upon a number of different clauses in the first instance hearing. He's now limited himself to a single provision, paragraph 22, which are buried within Rightmove's technical guidelines. This provision is not even within the main terms and conditions. It is within a set of technical guidelines concerned with technical matters, such as the specification of the software, connectivity, and technical requirements for the provision of the services. Little or nothing to do, in my submission, as I'll go on to show, with the party's commercial bargain. And still that clause, my lords, doesn't constitute the prohibition that my learned friend seeks to demonstrate. It says nothing about members having an agent as a client or what service may be provided to an agent, what service may be provided to any given client. It would make little commercial or ordinary contractual sense for paragraph 22 of the technical guidelines to serve that purpose, my lords, because it would in effect overwrite the majority of the remaining terms and conditions. In order for a client, a member rather, of Rightmove, to ascertain to whom he may provide services and what services he may provide, the member would not go looking in the terms and conditions or his application form or anywhere else. He would have to go to the technical guideline procedure, which, on the learned friend's case, requires individual applications to be made before a service may be provided possibly to anyone on his wider interpretation of paragraph 22, and then presumably the member would receive some written confirmation back from Rightmove, a written confirmation in a form and by a mechanism of which there is no reference and which we haven't seen anywhere. Rightmove hasn't even said it exists, and that is how the member would know what services he may provide to whom. And that, my lords, I submit, it makes absolutely no commercial or ordinary sense of the words in these contracts. But what paragraph 22 does say, my lords, is simply that a member must not sell on or provide access to the services and features of your membership to third parties. Now, my learned friend and I agree that the services and features of membership is the ability to list properties on Rightmove websites. It is, as I've called it, handing over the keys to a third party so that that third party may create its own listings. What paragraph 22 of the technical guidelines says nothing about is what the member himself may do or not do. It doesn't address or limit in any way who the member may have as a client or what services the member may provide to his clients. My learned friend's reliance on clause 22 is therefore simply misguided in my submission, as is his criticism of the judge for not grappling with it, as my lords have already seen this morning. It was addressed by way of clause 19, the analogous provision in the earlier terms. So that's the Rightmove terms. I'll come on in more detail to them shortly. But for clause 3.1.10 of the Zoopla terms, which again is the only provision on which my learned friend relies, this is at least in the main body of the terms and conditions, but it is of no assistance to my learned friend. Because as my lords are plainly aware, the Zoopla terms define two different types of members. There are, quote, agents, which means an estate agent, lettings agent, and in Scotland, solicitor agent, and or commercial property agents. And then there are online agents. And those are defined as an estate agent that operates primarily via a website, rather than a physical branch, and or does not operate through a local office network.
Is that right? It struck me that the definition of online agent was identical with that of agent, but then subject to a proviso that its business must primarily be on the website, so that online agent is a subset of agent. It's not distinguished from agent.
I think that must be right, my lord, yes. Subset, rather than two non-overlapping sets, it is a subset.
Yes, they're not distinct categories. You have agents, and then you have a particular type of agent, which is an online agent.
I'd agree with that, my lord, yes. But, my lord, the important point, if I may, is that online agents are defined precisely in contradistinction to agents which operate via physical branches or which operate via a local office network. And it's agreed between us that the company was an online agent because it operated exclusively via its website. It had no physical branch. So the first question is simply, my lords, whether clause 3.1.10 is concerned with online agents, agents which are not online agents, or with both. And as my lords have already been considering this morning, for the reasons my lords have already alighted upon, in my submission it's clear that the cause is concerned only with those agents who are not online agents, namely agents that have physical branches or local office networks. Essentially because that is what it says. The member warrants that each of its branch offices will only upload details of properties that they have received instructions for specifically at each branch office location, and that no branch office will upload details of properties originating from any other branch office location.
Well, online agents can have branch offices.
yes, my lord, I accept an online agent could have a branch office location, because an online agent is one which operates primarily via its website. I accept that.
And does 3.1.10 apply to those branch offices?
Well, if I'll answer that directly, my lord, but yeah, let's say there were an online agent which had predominantly its website, that was how it did most of its business, and it had, say, 3 branch office locations. I'd accept, of course, that that online agent wouldn't be permitted to upload details from branch office 1 to branch office 2 or 3. So the prohibition plainly applies to branch offices and branch office locations. I think I'd have to accept, my lord. Yes, that's with respect to a good point. It
the
doesn't
limitation...
have no application to. I suppose that's the right way to look at it. It doesn't have. It's not that it has zero application to online agents. It has zero application to online agents' websites. So if an online agent happens to have 3 or 4 branch offices, but it does its business primarily via its website, the clause would apply to its branch offices.
It's not that 3.1.10 can't apply to online agents, it's that it can only apply to physical branch offices.
Yes.
That's your case.
Yes. Thank you. Not a point which had arisen previously, but I think clearly that must be. So, my lord, those really are the overview submissions in relation to grounds 1 and 2, and since my submissions will be pretty short on ground 3, I won't set them out first.
Just on the overview, I understand all that, but we shouldn't lose sight of the fact, should we, that the reason that we are, and all the focus has been on whether there is a restriction or a prohibition, as it's been called, on allowing other commercial agents in, that focus is because that was the order that your client sought, because the summary judgment application seeks an order for a declaration that when they entered into the contract, the company was not prohibited under the Rightmove and Zoopla terms and conditions from placing adverts on behalf of other commercial letting agents. So that's the focus. In fact, you could say what we're looking at is whether there is whether there are provisions which permit.
Well,
your focus has been on prohibition, which puts the onus on the appellant. But why is that the focus? Why is it not? Well, here I am. I'm a commercial letting agent. I'm a member of Zoopla and Rightmove, so I can put my properties on there. Am I permitted to put Knight Frank and Rutley's properties on there? Why the focus on prohibition and restriction, other than that's how your clients started this off?
Well, I think the answer is because it's how we started it off, and in our view that would be adequate for our purposes at trial, or frankly negotiations in order to avoid trial.
I thought it was because it was your breach of the breach of warranty claim you were facing was a breach of 8.3 of Schedule 3,
yes,
which is a warranty that there has not been a default on any agreement or circumstances likely to give rise to a default, i.e. hasn't been a breach of. And in order for there to be a breach, there must actually be a prohibition. That's how I understood.
Those were to be, in less elegant terms, the next words out of my mouth.
Why you've chosen that as the formulation
So
in what you've been asking for.
But in your helpful overview, which I know you'll come back to, you in relation to Rightmove, you are able to put it on your case round the other way, because you say their terms do expressly permit it. You would accept that the Zoopla terms and conditions, you say it doesn't amount to a restriction, and I understand that argument. But I think there isn't anything in Zoopla which you can rely on in the same way. Is that right?
That's true, Neville. There is no analogous provision to the your client definition.
No. Well, that's very fair. All right. Mr. Goodkin, we'll ask you to start, but we do have to rise just before 1. So do start your submissions on grounds 1 and 2, and then I'll gong you off at an appropriate time.
Whenever suits my lords, of course. Right, my lord's factual background plainly is the court is very much abreast of it. There is just one point. I have sought respectfully to correct what I say are some errors in my learned friend's summary of the facts at paragraph 10 of my skeleton, which I won't rehearse now. Save my lords for one matter, which is the defendant's attempt, including within this appeal, to present themselves as the victims of untoward practices in relation to the sale of this company to them. It is not legally relevant for the direct purposes of this matter of interpretation, but it's perhaps relevant factual background.
Well, the facts remain to be found. So we
they
are concerned here purely with contractual interpretation.
I'm mindful of that, my lord, absolutely. There is just, well, it's relevant for other purposes. So I will, if I may, just go to a part of my learned friend's pleading, which is the defence in counterclaim in the core bundle, tab 13, page 131.
The email exchange is about the
My lord, yes.
what had happened in the past.
Yes, because I say this shows we did make perfectly clear what had happened in the past, and this also brings some colour to what would be prohibited from the court's consideration if ground 3 were found against me. So, my lords, in paragraph 6.4 here, the learned friend, this is pleading, pleads following the sale took place on the 20th of February 2017, and it's agreed there were some meetings in the month prior to that. And following those meetings, the learned friend pleads in 6.4, the third defendant emailed the first claimant at 11:06 on 8 February 2017 and raised a number of queries. The points which the third defendant raised included, inter alia, the following. The final point came from watching Darren accept a landlord advert, that's Darren Butcher, my lords, accept a landlord advert to find a tenant. The MyLet system showed this landlord had a further 60 properties in London. On our database, MyLet, have accepted these properties as being the property of that landlord. It is difficult to believe that one individual owns all those properties, and it begs the question, are we turning a blind eye to what looks like a letting agent getting Rightmove adverts, etc., at a significantly reduced rate? If this is the case, how can we ensure that there is no claim from Rightmove, etc., for breaching their rules in the past, and how do we ensure the software asks the question about whether the applicant is a letting agent or an individual landlord in the future? And Mr. Butcher replies 50 minutes later or so and says, to be honest, we've left this pretty much to Rightmove or Zoopla. They did have a period when they were upset about all this, but lately seem to have gone quiet. We look at landlords' email addresses, obvious things, e.g. bill@propertyagent.com. But other than that, without asking for proof of ownership, there isn't a lot we can do. If Rightmove or Zoopla have complained, we've investigated and blocked them. Seems to have worked so far. So a straightforward question is asked and a straightforward answer is given as to what the company does and doesn't do in order to ascertain the identity of the clients, and also a relatively straightforward answer as to Rightmove and Zoopla's prior position. It's agreed, I think, that there was no follow-up to this. If the defendants were in any doubt about what any of this meant or wanted to know more, they could have asked. But my clients have made very clear an overview and summary of what is done and what isn't done. And so, my lords, on the learned friend's interpretation of clause 6.2 of the contract of sale, the judge would be unable to take any of this into account, even though it's been pleaded by my learned friend. This would all be this would be prevented from being taken into account in deciding whether there has been negligent non-disclosure. And that, in my submission, would be a relatively bizarre outcome. My lords, I was going to move on then to ground 1 proper.
Let's pause there. Hang on a minute, I just want to note that down. Yes, all right, thank you very much. We'll come back at 2 o'clock, please. Thank you.